A three-judge panel of Ohio's 4th District Court of Appeals heard oral arguments Thursday in two Highland County criminal cases regarding charges of engaging in a pattern of corrupt activities. Attorneys for the appellants questioned if the corrupt activities charge should have been applied to the case, and if the local trial court should have allowed the net amount of money seized in the case to be applied to the individual defendants. Highland County Prosecutor Annika Collins argued on behalf of the state in the two separate cases against Zachary Bondurant and Jeffrey Stevens. Judges William Harsha, Matthew McFarland, and Peter Abele heard the arguments Thursday morning in Adams County Common Pleas Court. On appeal, Bondurant is being represented by attorney Eric Allen, and Stevens is being represented by attorney Brian Hicks. Neither defendant was present for Thursday's hearing. The two stood trial in Highland County Common Pleas Court in August 2011. They were each found guilty on first-degree felony charges of engaging in a pattern of corrupt activities, trafficking in drugs, and possession of drugs. 7 co-defendants had previously pleaded guilty on charges in the case.
As I'm reading through the state's brief and they're talking about the RICO Act, that this certainly wasn't like the Gambino crime family. This wasn't like the Bonanno crime family. Looking at the record as a whole, the part that Mr. Bondurant played, all I could see was the allegations may have been handling some money and between the two parties. So I'm not sure that warrants the sentence that's north of 10 years.
This isn't the Gambino family. This also isn't New York or Chicago. This is Highland County. And when you put that in perspective, this was a huge group of drug traffickers that were moved from the streets. And it has significantly affected the heroin production and sale in Highland County. None of these people had jobs. They were funding their entire livelihood, everything fully paid for, with the sale of drugs. And it bought cars, it bought homes. $36,000 in the back of a Jaguar, along with 3 other vehicles. We seized 11 acres and a house that was completely paid for. This statute is directly related to the federal statute. That statute was written to get people like Mr. Bondurant, the low-level people, the smallest people in the chain. And that's what we did here. We netted the smallest fish, as they say in the federal case law. And that should be upheld. That is the purpose of the statute, and that's what we did in this case.
That seems to be a massive waste of resources to try and get low-level dealers as part of some massive conspiracy when the head of this conspiracy is allowed to plead and testify against people that may or may not have been working for him.
There is no de minimis violation of the law. And if you have to have $500 in the enterprise for each person, what about the person that doesn't actually sell drugs but protects the highest person in the chain? Does he not become part of the enterprise? He knows everything that's going on. He transports drugs back and forth and gets no money. Or these low-level drug dealers that are selling for $20 at a time to kids or to mothers or fathers or whoever has to do 40 transactions before we can bring them in, that doesn't make any sense. That's not the intent of this law, and was not the intent of the legislature.
You can bring them in with one transaction. It's trafficking. It's just not under the correct activity.
That's true. But are you doing what again the legislature intended? Are you stomping out this kind of activity with one? No. Right now we aren't even allowed to put that person in prison. If it's an F4 and F5, they get community control. So that's not doing what the statute intended either. And it very clearly says that it was intended to authorize a single prosecution of multifaceted, diversified conspirators.
I find it interesting that the federal courts have never addressed this with all the RICO activity that they...
Well, Your Honor, to be honest, I suspect that most RICO charges don't have the under $500 issue. I suspect that the reality is RICO was designed because it was a big problem. And we had massive enterprises engaging in highly diversified operations. And Congress said, you need another tool.
Hillsborough is not Chicago or New York.
Even in Highland County, the evidence established at trial was that my guy made less than 5 transactions total. That they can say, yes, we know he did this. And the value of it was like $243 or $46 or something like that. We're talking about a really big player. And she has her theories that, you know, maybe he was bigger, maybe he was this. That's the jury didn't find any of that.
A judgment on the cases will be issued by the Court of Appeals in the coming months.